is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's session. In today's session, we're continuing with our ongoing and new emergency broadcast related to recent decisions of the Division of Workers' Compensation to issue discipline to qualified medical evaluators for purported misuses of the complexity factors and for allegations of overbilling related to misuse of the complexity factors under CCR 9795. And as I said, this is our second session of this emergency broadcast. In session one, we talked about the current climate of QME evaluators being denied their renewal application for their QME credentials, and the basis of those denials based on the limited information that we have available. Now, much of what we're talking about with regards to information that we have related to the DWC has to do with anecdotes and unpublished information, with the exception of some recent light that's been shed on the matter by the filing of a lawsuit in Southern California by several doctors who've come together to sue the Division of Workers' Compensation for what is referred to in the lawsuit as underground regulations. And what this means is that according to this lawsuit, the Division of Workers' Compensation has developed a new interpretation of the complexity factors under CCR 9795. And this new interpretation takes the entire QME base by surprise, because there's no way any qualified medical evaluator could ever have the same interpretation of the complexity factors that the Division of Workers' Compensation is now adopting as the new complexity factors. So likely every single qualified medical evaluator can be construed as being in violation of the new interpretation of the complexity factors. And this lawsuit coming out of Los Angeles alleges that the Division of Workers' Compensation is imposing these new complexity factors without going through the proper due process and without having the language of the complexity factors properly and legally changed in order to reflect the Division of Workers' Compensation's new interpretation of the complexity factors. So we're in quite a bit of a quandary here, because hundreds and hundreds of qualified medical evaluators have been denied their QME credential renewal through no intentional fault of their own, but simply through doing what they've conventionally done for years and years, but for which is being interpreted now by the Division of Workers' Compensation as improper use and an improper application and an improper interpretation of the complexity factors. So in session one, we talked about complexity factors of face-to-face time. We talked about review of records. We talked about medical research. We talked about 4 or more hours. We talked about 6 or more hours. And we started in discussing the complexity factor of medical causation. And I've given several suggestions with regards to those complexity factors as to how your reports can comply with the DWC's new interpretation of the complexity factors, at least during the time period where these disputes over the complexity factors are being resolved. As I said, there's an ongoing lawsuit just filed in Los Angeles that is taking the Division of Workers' Compensation to task. And so I anticipate, although I'm not a lawyer and I'm not familiar with much of the process involved with these lawsuits, I anticipate that soon the Division of Workers' Compensation will have to answer for itself and its actions, and will have to make some sort of an adjustment, at least in terms of notifying us out in the trenches, us qualified medical evaluators, out in the trenches as to what's expected of us and what we're supposed to do with regards to billing our reports properly under the medical legal fee schedule. Now today, I want to talk to you about two more of the complexity factors, and then in our third session we'll finish up with a discussion of the ML 103 and ML 104 billing levels and talk about what it's going to take now in this new climate for your report to properly qualify as an ML 103 or an ML 104. So for today, I want to continue our discussion about the causation complexity factor and then also the apportionment complexity factors. And let's begin today's discussion with the apportionment complexity factor. I think we can handle the apportionment complexity factor fairly quickly here and then get on to our main discussion, which is a continuation of the causation complexity factor. Okay, so I have some materials here to share with you today. And with regards to the apportionment complexity factor, it's my opinion and it's my experience that you will use the apportionment complexity factor very, very, very rarely, because the new language of the apportionment complexity factor creates a very high threshold for the use of apportionment to qualify as a complexity factor. In very, very few reports, certainly few of the reports that I've ever done, actually qualify for a complexity factor for apportionment, because the threshold is just so high. Now, to illustrate this, let me read the exact language of the apportionment complexity factor. It says, addressing the issue of apportionment, comma, and hereafter they cite the specific circumstances wherein a discussion of apportionment qualifies for a complexity factor. Now, many doctors get this wrong. They simply bill for apportionment as a complexity factor when they handle Part A of this description, which, as we said, simply states addressing the issue of apportionment. And some of the doctors who've had their QME credential non-renewed have been non-renewed for misuse of the apportionment complexity factor, wherein in their report, their description of the apportionment complexity factor simply states, quote, apportionment was addressed, period, unquote. And that's not the entirety of the requirement of the apportionment complexity factor. So it says, addressing the issue of apportionment, comma, when a determination of this issue requires the physician to evaluate the claimant's employment by three or more employers, three or more injuries to the same body system or body region, or two or more injuries involving two or more body systems or body regions. This is a very tall threshold. When was the last time you evaluated an examinee who had industrial injuries with three or more employers for which you were required to apportion a certain percentage of the permanent impairment amongst those three employers? I've not had such a case. That's a very tall threshold. When was the last time you had an examinee who had three or more injuries to the same body part that required you to apportion the permanent impairment amongst those separate and distinct injuries? It's a very tall threshold. Similarly, two or more injuries involving two or more body systems that requires apportionment is a very tall threshold. So it's my opinion that the apportionment complexity factor is something that you will use very, very, very rarely. if at all. I can't remember the last time I had a report that incorporated the apportionment complexity factor. Now, this is somewhat in contradiction to Labor Code 4663 and 4664, which are our apportionment labor codes. And Labor Code 4663 states that in every instance where you as the qualified medical evaluator provide an opinion for permanent impairment, your opinion must also include a discussion of the apportionment of the permanent impairment. So in those cases where there's permanent impairment, the apportionment discussion is required. It's mandated. It's required by law. It's required by Labor Code 4663. So you must address apportionment in those cases that involve permanent impairment. However, that does not qualify your apportionment discussion in those cases as a complexity factor. The discussion of apportionment is required, but it only qualifies for a complexity factor when the apportionment determination is complex. It's so complex, and it's defined as complex by requiring 3 or more employers, 3 or more injuries to the same body system or body region, or 2 or more injuries to 2 or more body systems or body regions, which is a very tall threshold. So my advice to you on the apportionment complexity factor is don't use it. Don't use it. Don't cite apportionment as a complexity factor unless you have one of those rare reports that meets this tall criteria. This is new language in the apportionment determination, by the way, that creates a tall threshold for apportionment as a complexity factor. Even in those cases where we are required to address apportionment, that apportionment discussion does not qualify as a complexity factor unless the apportionment determination is complex as defined in the complexity factor and the language of the law under CCR 9795. So you will rarely, if ever, use apportionment as a complexity factor. So just eliminate that from your whole template. You can eliminate that from your whole thought process. No longer is simply a statement such as apportionment was addressed going to qualify as a complexity factor. Okay? So that should pretty much handle the discussion on apportionment. And some of the doctors that are having their QME credential non-renewed deserve such, as much as I hate to say it. They deserve to be disciplined. I'm not saying they deserve to have their QME credential non-renewed, but they do deserve some sort of a discipline for invoking the apportionment complexity factor when in actuality the report doesn't qualify for the apportionment complexity factor because it doesn't meet the tall criteria described in the letter of the law. Okay? So that'll pretty much handle the apportionment determination and the apportionment complexity factor. So let's back up a little bit now and let's talk a little bit more about the causation complexity factor, because it seems that the causation complexity factor is frequently cited by doctors in helping their reports qualify for the ML103 and ML104 billing levels. So after the other criteria such as face-to-face time, such as review of records, such as 6 or more hours, etc., after those criteria are met, the additional complexity factor of medical causation is used by many doctors to help their reports qualify for the higher billing levels of ML103 and ML104. But recently, the Division of Workers' Compensation has changed yet again their interpretation, if not the language, of medical causation as a complexity factor. So let's talk about what I refer to as the trickle down of medical causation as a complexity factor, and shed some light on the DWC's new interpretation of causation as a complexity factor. Now, those of you that were around before 2013 will remember that before the passage of Senate Bill 863 and the writing of the new QME regulations, the medical causation complexity factor, as described in CCR 9795, had different language than what we have now. Now, the medical causation complexity factor is simply defined as addressing the issue of medical causation, comma, upon written request of the party or parties requesting this report. So you, like apportionment, simply addressing medical causation does not qualify as a complexity factor. And many doctors in the report will simply state causation was addressed and expect that to qualify their causation discussion as a complexity factor. And those doctors are receiving discipline because their causation argument in the report doesn't meet the criteria as described in the law. So now the issue of medical causation qualifies for a complexity factor when you address it if it's been requested by the party or parties requesting the evaluation. Now, before this new language was adopted, this description was a little bit longer. It used to state, upon written request of the party or parties requesting the report, comma, or, comma, in the event that a bona fide issue of medical causation is discovered in the evaluation. That last phrase has been removed. Now, that last phrase was the phrase that gave the doctor, the QME evaluating doctor, the authority to invoke medical causation as a complexity factor when the doctor discovered a bona fide issue of medical causation in the evaluation. Like what? Like what could qualify as a bona fide issue? Like how about an examinee showing up and claiming additional body parts than what are described in the cover letters that you have received? Or the examinee describing multiple dates of injury when the information that you've received describe only one or only two or fewer number of dates of injuries, and these are things that the doctor needs to investigate. Bona fide issues do have a tendency to arise during the course of evaluations with these unpredictable injured workers. But the authority of the doctor was removed when that last sentence was deleted from the language of the medical causation complexity factor. Now, the doctor has no authority to invoke medical causation as a complexity factor of his own authority. Now, so there's been a trickle down, okay? Used to be that the doctor had the authority. That's been removed. So medical causation and the usage of medical causation as a complexity factor lost a broad range of uses as doctors lost their authority to invoke causation as a complexity factor. So there's the first trickle down of medical causation. Now, medical causation can only be addressed upon written request of the party or parties requesting the evaluation. Now, that otherwise would not be such a big deal because the cover letters that we receive from the parties, whether that be the claims administrator, the applicant attorney, the defense attorney, those cover letters frequently include requests for discussions of medical causation. So there, upon receiving these written requests, the QME evaluator, the doctor, has been given the authority to address medical causation and to invoke medical causation as a complexity factor. So for this authority, we simply need to look no further than our cover letters. And cover letters usually have requests from the parties for an addressment of medical causation. So up until now, causation as a complexity factor has not been an issue as long as we can demonstrate a written request. Okay? Well, it now seems, based upon the new interpretation of medical causation by the Division of Workers' Compensation, it now seems that a written request to address medical causation is no longer enough for the doctor to employ medical causation as a complexity factor. So let's think about this for a minute. What are the instances and what are the circumstances and what are the scenarios under which medical causation can correctly be applied as a complexity factor? Well, it seems to be the position of the Division of Workers' Compensation that medical causation qualifies only as a complexity factor, or I should say qualifies as a complexity factor only in those cases that involved denied, delayed, or investigated cases. These are the cases that we get under Labor Code 4060, the compensability exam, the denied case, the delayed case, the case that has a relatively recent date of injury for which compensability is in dispute. Of course, certainly those cases require a discussion of medical causation to determine compensability of the claim, so that the claim can either move forward or can be snuffed out as a non-accepted claim. So there is a valid use of medical causation as a complexity factor, and this seems to be the application of medical causation that the Division of Workers' Compensation pigeonholes and buttonholes medical causation into. Well, what about accepted cases? The position of the Division of Workers' Compensation is, in the context of an accepted case, you will never, never need to employ medical causation as a complexity factor because, according to the Division of Workers' Compensation, once the claim has been accepted, medical causation is no longer in dispute. So, what does that mean for the cover letters that we get that ask us to address medical causation? Why would the claims administrator, why would the applicant attorney, why would the defense attorney request a discussion of medical causation from us in the context of an accepted claim? I can think of probably a dozen reasons. I can think of a dozen reasons. Doesn't the claims administrator have the authority to request a discussion of medical causation? Doesn't the defense attorney have the authority to request a summary, a synopsis, a review, a new discussion, an update, a conclusion on medical causation from the qualified medical evaluator? Don't they have the authority to get the current story, the current opinion, the current idea as to the totality of the medical causation? Don't they have that authority to request the qualified medical evaluator to address that? It seems that they don't. It seems that they don't, because it's the position of the Division of Workers' Compensation that medical causation as a complexity factor cannot be employed in the context of an accepted claim. Now, this language is nowhere in the written letter of the law under CCR 9795, but the Division of Workers' Compensation is seeing things a little bit differently. And I want to read for you a couple of excerpts from this recent lawsuit that's been filed in Los Angeles as relates to the medical causation complexity factor. And let me just scan my notes here very quickly. Okay, have all that. Have all that. Have all that. Okay, so if you think about that, that's another example of trickling down of the causation as a complexity factor. The authority of the doctor has been removed. The authority of the claims administrator, the defense attorney, and the applicant attorney to request an addressment of medical causation has been removed. Trickle down now, and now it seems that the only possible application of the use of medical causation as a complexity factor applies in denied cases where 3 criteria exist, and I'll share those 3 criteria with you here shortly. So according to this new lawsuit, and I apologize if you hear some noise in the background, there's some heavy equipment being operated outside. But one of the accusations against the Division of Workers' Compensation levied or lodged by this lawsuit states that medical causation is a valid complexity factor under ML 104 when a party simply requests that it be evaluated. In other words, when we receive a written request from the party or parties requesting the report. And I remember attending a recent seminar about how we as qualified medical evaluators can improve the content and quality of our reports. And it was interesting, this seminar was not conducted by qualified medical evaluators. It was conducted by applicant, defense attorneys, and workers' comp judges, all of whom are hoping and seeking better reports from qualified medical evaluators. And one of the panel members, who was a defense attorney, lamented and moaned that qualified medical evaluators do not answer the questions that are contained within the cover letters. And he simply stated, "Would you please answer the questions in the cover letters?" And of course, many doctors in the audiences raised their hand and explained that sometimes we don't get cover letters. Sometimes the cover letters seem to be generic, boilerplated, templated, non-customized cover letters, and they don't seem to apply in every instance to the particular examinee. To which the defense attorney put his head in his hands and he shook his head and he replied that the cover letters that we receive are the cover letters. Would you please address the questions at least in the cover letters that you receive? So it would seem simply getting a request to address causation would be sufficient to address causation and use causation as a complexity factor, but apparently it's not. However, the Division of Workers' Compensation have imposed 3 additional requirements: that there also be, number 1, a contested claim putting causation at issue; number 2, a denied claim; and number 3, a letter from a party specifically stating that medical causation is an issue. That medical causation is an issue. Now, nowhere are those 3 requirements contained within the language of CCR 9795. Respondents have imposed new criteria. First, requiring that there be a contested claim putting causation at issue, thereby precluding the use of this factor where an industrial injury appears to be accepted. Second, that there be a denied claim, thereby also precluding the use of this factor when an industrial injury appears to be accepted. And third, the Division of Workers' Comp is requiring specific words stating that medical causation is an issue which must be included in the written request of the party or parties requesting the report, now causing further trickle down of causation as a complexity factor by creating very tall criteria and a very high threshold for the use of causation as a complexity factor. So what does this mean? It means that when you receive cover letters that ask you to address medical causation, you've got some work to do. Those requests do not signal your authority to invoke causation as a complexity factor. No, you now have some work to do. It's up to you now to determine that there is a contested claim putting causation at issue, that there is a denied claim, or that third, whether or not medical causation is an issue. So how are you supposed to do this? Well, you're supposed to do it. They don't tell us how we're supposed to do it. But I surmise that you're supposed to do it by either phone call or by letter to find out if any of these three criteria exist so that medical causation can apply as a complexity factor. Now, there have been some doctors who've been disciplined on the use of medical causation as a complexity factor, and I've read some of those accusations, and from the reports that I've seen of those doctors, I agree with the Division of Workers' Compensation that those doctors did a poor job on elaborating on the necessity of the use of causation as a complexity factor. One of the denials from the Division of Workers' Compensation to one of these doctors stated, as to the cited complexity factor that the report addressed causation, Dr. Jones stated in his report that causation was due to the industrial injury. There is no indication that this was a contested claim putting causation at issue, or that either party requested a causation analysis as part of the QME evaluation. So it appears that since neither party requested a causation analysis, that the doctor addressed causation without a written request of the party or parties requesting the report. And it's probably for that reason that the DWC disciplined this doctor, because he had the audacity to invoke causation as a complexity factor without even a written request. Should that qualify for discipline? In my opinion, it probably should. He didn't have the written request. So what should you do in those cases where you invoke causation as a complexity factor? What you should do is you should pound the parties, pound them over the head with your authority to use causation as a complexity factor. Show the cover letters. Cite the requests that you address medical causation in your report. Under your causation complexity factor, cite the cover letters and the requests from those cover letters. Include the cover letters with the copy of your report. That's two things. Include the cover letters and cite the cover letters within the body of your report. Handle both of those. That way, if the cover letters and the report ever get separated, at least your report references the cover letters, which can be easily tracked down. This doctor did not do that. In fact, he simply went ahead and addressed medical causation without a written request from the parties. So in his case, there was two things, according to the Division of Workers' Compensation, that he failed to do. He failed to recognize that there was no dispute over industrial causation. In fact, he stated that causation was due to the industrial injury. What a basic causation analysis that is. There's no other factors that contributed to the causation of the injury. The causation was due to the industrial injury. That was all he said. So where's the dispute? There's no dispute there. And second, he didn't cite his authority by demonstrating the written request from the party or parties. There was no indication that this was a denied claim. Therefore, medical causation was not at issue and could not be claimed as a complexity factor. Now, it's my opinion, and this is simply my opinion. This has no authority to it whatsoever. I believe, and it's my feeling, that if you have a specific request to address causation from the parties, that is going to qualify as a complexity factor in both denied and accepted cases. That's my feeling. Now, right now, the Division of Workers' Compensation is stating that causation will not qualify in accepted cases. But I submit that if the parties request an addressment of causation, if the insurance carrier is willing to pay for a complex report, is willing to pay you for your discussion of causation, shouldn't they have that authority? Don't they have that authority to request that you address whatever they want you to address that helps them in the management of their claim? If the parties ask it and you have a written request, I believe it's going to come around. This is just my feeling. This is just common sense feeling, that causation will then qualify as a complexity factor, but still it's going to be predicated on the fact that you have a written request from the party or parties. Okay? But as of now, it's the position of the DWC that causation only qualifies in the presence of a denied claim. But I think that's going to work itself out. The Division of Workers' Compensation, therefore, with this new interpretation, has changed the meaning of 9795 by adding new and different criteria to the causation complexity factor, that the party's written request to address medical causation must also include the specific words, "Please address the issue of medical causation." And I don't see that to be as a problem, because most of the cover letters that we get have language very similar to that effect. And let me share some of those cover letters with you. Okay? That's the basic position of the Division of Workers' Compensation on medical causation. It's just to trickle down causation as a complexity factor, such that its uses have dwindled down until very narrow criteria as they're currently relying on in reviewing doctors' reports. But I have a couple of cover letters here, and these all, in my opinion, would qualify medical causation as a complexity factor, because these cover letters contain a specific request for an addressment of medical causation. So let me read this one to you. This is a cover letter from a defense attorney. It says, and this is the type of language that you're going to look for in your cover letters that provide the authority for you to address medical causation. It says, applicant Betty Smith has filed 2 workers' compensation claims during her employment with ABC Enterprises, which are the subject of your evaluation. Both are the subject of the evaluation. The first is a April 1st, 2011 specific injury to the right knee. This claim is accepted. The second is a cumulative trauma through December 31st, 2016 to the knees and lower extremities. The CT is denied based on a lack of medical evidence of industrial causation. So here we have a denied claim. Here we have a dispute over medical causation. Later on in the report, there's templated language. There's boilerplated language. But then the attorney inserts a piece of customized language. It says, further, please address whether you find industrial causation for the alleged cumulative trauma injury and explain your reasoning. So this is an example of authority to invoke medical causation due to a specific request. Number one, you have a specific written request from the party or parties requesting the evaluation, and this would satisfy the Division of Workers' Compensation because it involves a denied claim where medical causation is in dispute. Okay, another cover letter. This one is also from a defense attorney. Talks about the injury, and it says on June 1st, 2016, there was an incident. The incident was not witnessed, and it was not immediately reported. 3 days later, she reported the injury and sought formal treatment after allegedly sustaining a second low back injury. Defendants admit that Ms. Smith sustained a low back injury on April 1st, 2016, but the April 15, 2016 claim was denied, as defendants are uncertain as to whether the first incident is a new injury, or the second incident is a new injury or is an exacerbation of the first injury. And there's a request that says, please advise if Mrs. Smith sustained a work-related low back injury on the second date in addition to the industrial injury on the first date. So herein contains a specific written request to address causation in the context of a denied claim. This is the type of thing that would satisfy the Division of Workers' Compensation. And a couple of the cover letters that I have are similar in that they represent denied claims. So let's summarize what we know so far. What we know is that the Division of Workers' Compensation is having some difficulty with the use of causation as a complexity factor in accepted cases. Now, I disagree with this completely because there are occasions, meaning every single case, not just occasions, but every single case, wherein the cover letters that we receive specifically request us to address medical causation. And like the frustrated defense attorney at the seminar I attended said, please address the questions in the cover letter. What are you supposed to do if you're not supposed to address the questions in the cover letter? But the Division of Workers' Compensation is recommending that in accepted cases, you take your inquiry a step further and inquire as to whether or not the claim has been accepted or denied, whether or not medical causation is an issue in dispute or not. And it's the position of the Division of Workers' Compensation that in accepted cases, regardless of the written requests that you receive, in accepted cases, medical causation will not qualify as a complexity factor because medical causation is no longer in dispute. I believe that this is going to iron itself out, and medical causation will qualify as a complexity factor even in accepted cases, but I'm just sharing with you what the controversy is, and as it exists today, and as it's described in an ongoing lawsuit that's coming out of Los Angeles. So doctors, I hope this helps you. I hope this helps you to relook at your own reports and your own billing for your complexity factors. Now, more than ever, your complexity factors need to be substantiated, and substantiated. And if you have poor or weak substantiation, according to the letter of the law of the cover letter, my advice is don't use that complexity factor in your billing level, because the doctors that are using the complexity factors without adequate substantiation are running into harsh discipline, and you don't want that to happen to you. Okay? Now, in our next discussion, we're going to talk about what the DWC's current position is regarding the ML103 and ML104 billing levels, and this is going to blow you away, because their interpretation of the ML103 and ML104 is something that you could never predict. You couldn't make this up in 1,000 years. If you tried to construe this interpretation yourself, you could never come up with this. But in their cleverness, the Division of Workers' Compensation has put a twist on the ML104 billing level that makes it nearly impossible to achieve. The threshold for the ML104 has become like Mount Kilimanjaro. Very difficult, very high threshold, very difficult, and very few reports, that is, will ever, at least according to the DWC, arrive at the lofty ideal of the ML104 extraordinary medical legal report. So we'll get into that in our very next discussion. So for now, I hope this helps you to stay safe and stay out of scrutiny with the Division of Workers' Compensation. So this is Dr. Perry Carpenter, thanking you for joining me today, and I look forward to being with you on our next session as well. And for now, I'm wishing you best of luck in your career as a qualified medical evaluator.